Hello and welcome to yet another episode of Law Matters, a program that looks at matters that are complex in matters of law and breaks it down to bits that are manageable for us and also for all who are interested in these particular matters. And I'm happy today because we will be engaging in a topic that is rather perceived uncomfortable, but one that is necessary to be divulged in. And also, I'd want to note the presence of a live audience who, in that part of the show, will get the opportunity to share their questions on this topic of concern. What am I talking about? Well, it's a matter that is of concern, particularly for parents and also individual as a person, particularly as it comes to matters of what property you have or what you have amassed and how it can be distributed when you are not there. I'm talking about how succession does happen. And something that is of concern is that if you may fail to put your matters in order, as it would be termed, there is a possibility that those who you look at as special people in your life, who you'd want maybe to allocate part of your property, may not receive it because you did not plan for it. Well, I'm not the authority on these matters. I am in class just like you, and I'm happy to be in the company of an advocate of the High Court who is able to break it down. Hilary Musoma, welcome to Law Matters.
Thank you so much.
And I appreciate your time here in helping us break down this whole wide topic in manageable chunks.
Thank you.
Yeah.
Thank you so much.
And something before we get into our topic is that I have I have the opportunity to have some knowledge that you are an alumni of the Kenyatta University.
Yes. Yeah. Thank you so much for the opportunity. Maybe just to introduce myself, I am Musoma Hilary, advocate of the High Court of Kenya. I am an alumni of Kenyatta University School of Law. I was admitted on the 26th August 2019 and graduated on the 15th December 2023 before I joined the Kenya School of Law and finally got admitted as advocate on the 20th November 2025. Yes.
Well, and I guess you are a testimony of how the Kenyatta University is able to nurture the next level of advocates, particularly within the Democratic of Kenya, which is becoming quite aware on matters of legal awareness.
Yes.
And with that guide, I guess we can be able to agree
yes.
that Kenyatta University is doing something about it.
Sure, and not really to blow our own trumpet, but facts speak for themselves, and facts are so loud. Kenyatta University chunks out the best of lawyers.
Yes.
Yeah.
And we appreciate, of course, within our audience, we do have others who are coming up through the same channel that you came through
sure.
to arrive where you are at.
Yes.
And perhaps just now go straight into the matters. Wakili.
Yes.
What does it mean to die? And particularly to die interstate?
Death in an intestate status simply means that a person died without having control of the affairs of their estate or the affairs of their property before they died. And dying intestate can arise out of different scenarios. Scenario number one, a person dies without having written a will. Scenario number two, a person dies having written a will, but this will is nullified by the court. Scenario number three, a a person writes a will, revokes this will before he dies, does not write a subsequent will, and dies before he writes a subsequent will. Mm-hmm. These circumstances will lead to a status called an intestate process, mm-hmm. where you die without a will, or the will is nullified by the court, or you write a will, revoke it, and die before you write another one. Mm-hmm. Yes.
And perhaps for you to now speak to us from your point of understanding, and draw us in. Why is it a big deal?
It is a big deal because, one, if you die having written a will, first, the status is called testate. If you die testate, it means you have put your affairs in order. Mm-hmm. If you write a will, it means you have identified your property. Mm-hmm. So there is clarity as to what your property is. Two, you have gifted those you intend to gift, mm-hmm. as beneficiaries of your estate. Mm-hmm. You would want to gift your friends, you'd want to gift your parents, you'd want to gift orphanages and charity organizations, you'd want to gift the church. Mm-hmm. But if you fail to write a will, then the law applicable in distributing your estate as a deceased person would then not be a will or certain wishes that you may have embodied with yourself to be able to distribute that property. So the law will be the one to distribute your property, and the law will not care about who you loved most, who you didn't love. It will distribute that property that way, according to the rules which we will discuss, I believe.
Yes, and before we go into that heart of the matter, there are things you've noted that keep you in an intestate capacity. Among them is not taking time to
write the will.
Yes. The second point is nullifying.
Yes.
I believe the first and the second are quite self-explanatory, because one, you did not write one.
Yes.
Second, you wrote, you revoked, but you did not write another.
Yes.
But coming to the nullification,
yes,
by the courts.
Yeah.
How does that come about?
The courts can actually nullify a will. And the court there are certain grounds in law in which a will can be nullified. First, there are elements in which a will has to meet for it to be a competent will. Number one, any written will must be witnessed by at least two independent, competent witnesses. Two independent, competent witnesses. And I have to explain what independent, competent witnesses mean. Mm-hmm. A competent witness is a person who can be able to attest to a document. For example, a child who is below 18 years, or a child, anybody who is below 18 years, mm-hmm. cannot be a witness to a will. Mm-hmm. Number two, a person who is not of sound mind cannot be a witness to a will. Number three, if any of the witnesses is a beneficiary in the properties allocated or awarded in that will, then the will does not automatically become incompetent. But if both of those people are beneficiaries in that will, then that will collapse. If at all the properties that have been listed in the will are allocated to the two witnesses, the will collapse. And what is the remedy then of these two people, or any person who is an independent, competent witness? If you and I, for instance, are witnesses to a will, and I am a beneficiary, I have been listed as one of the beneficiaries in that will, I have to have two substitute independent witnesses in addition to myself. So to avoid the big drama and the crowd, the deceased person or the testator, before they die, have to just ensure that whoever they are getting as independent, competent witnesses, lawyers would advise that they should not be beneficiaries to this estate, so as to avoid any other thing that will come to nullify the competence of that will. Number two, any will that is procured out of fraud, out of coercion, out of intimidation, forged wills, those are grounds for nullifying a will. So yes, a court has the authority and it can nullify a will. And when the will is nullified, the estate now goes intestate.
So we go back.
To now we will assume that you died without a will.
Anything about it.
Correct.
Well,
and just before you move, perhaps, if both of us are witnesses to a will, and I am a beneficiary listed and you are not, and the will goes ahead, the will not collapse. But that property which I have been gifted in the will, because I was a witness to it, it lapses, it fails, it will not devolve to me. It instead will be treated as intestate. It will be treated as though this person died without having written a will on that property which I was gifted, because I was a witness to that. So to cure that, I have to have two more independent witnesses just to witness that which I was allocated. That is why we advise whoever is writing a will should avoid as much as possible not to have persons who are beneficiaries in that will as witnesses to the will. Yeah.
Kili, I'm worried somehow, but you're going to walk me out of my worry.
All right.
I'm imagining a situation where, or rather just to phrase the question this way, who needs to have a will? I'm looking at myself as someone who doesn't amass that much, but I do have something.
Yeah.
How do I come to drafting a will? Is it something that I can be able to write down myself and decide this is my will? Or can you just guide us as to how we move it into becoming a legal document?
There are no formalities or formula of drafting a will. You can draft your will whichever manner you so deem fit. You can draft it alone. You can draft it through your advocate. The only reason why most people would seek the services of a lawyer to draft the will is because the advocate will advise them on listing all properties, identifying their properties, and knowing how to distribute them, and even the language that is used in the will, so that to avoid any ambiguities that will be in the will. Most of the time, we do not want to give the court time to try and interpret the will, because that is not the function of the court. The court does not interpret the will. The court applies the will as it is. So it's not the function of the court to reinterpret, try to decipher what was this to mean. That is why people seek the services of a lawyer in drafting the will. Otherwise, any person has an estate. Even you have an estate. Even a child has an estate. Any person has an estate. Whatever property you own forms part of the estate, even clothes.
Okay. We're going to go back to the topic that we were moving on.
Yeah.
I want to understand, since I have an estate.
Yes.
How, or rather, give me a situation where I am now, someone has moved on, they're intestate.
Yes.
How does the court come to break down their property now? Like, what would be the hierarchy?
I would answer like an advocate. It depends. First, it depends with the situation in which you died intestate. You can die intestate under different circumstances. First, you can die intestate having a wife and having a child or children. You can die intestate having no wife, because either she predeceased you or you divorced, but you have children. You can die intestate having a wife with no children. You can die intestate having many wives and many children. You can die intestate having no wife and no children. So it depends. Yes. So we can break it down. We can break it down. You see, the reason why I said it's important to write the will is because the Law of Succession Act will not have the affairs into meddling with your property. But if you die without a will, now you give the Law of Succession Act the full mandate to come and meddle with the affairs of your estate. If you die with a wife and this wife has a child or children, the property is going to be devolved this way. First, all your personal belongings would vest in your wife. Absolutely. With absolutely, I mean they will be hers. Your clothes, your spectacles. If you had your bottle of Uji, all those things that you consider personal, those ones will be your wife's. The other property that was generating income that you own, whether hard property, vehicles, land, shares in companies, and all any other thing that you'll call property, she will hold something called a life interest in that property. That property does not belong to your wife. She is holding it in trust of your child or your children. In essence, she can't sell this property. She can't do anything with this property. She's holding it in trust of your children. So if she wants to sell this property, then she'll have to seek, one, the authority of these children, if at all they're above 18 years. They have to consent in writing. But if at all these children are, for example, not 18 years, then she has to get a court order to allow her to sell this property. Otherwise, this property does not belong to your wife. The only property that belongs to your wife, when you predecease her and she's left with the children, are your personal belongings, including your clothes and your spectacles. That is if you die and left a wife and children or a child. If you die and you left no wife, but you left a child or children, the entire estate devolves to your child or your children. In essence, your children will inherit everything and anything that you own. If you have one child, they'll inherit everything. If you have 2, 3, 4, 5, 10 children, they will inherit everything, but they will be distributed equally, whether they are boys or girls. If you die, having left a wife with no children, your wife is entitled to inherit your personal belongings, as we spoke about. Number 2, she will inherit the first 10,000 shillings or 20% of the remaining estate. Absolutely. Whichever is higher, whichever is greater. Listen to this again. You die. You have left a wife but has no children. She first inherits your personal belongings.
And some 10,000.
Yes. Hold on. She first inherits your personal belongings. That is the first thing she'll inherit, absolutely. Now we go to the property. She will inherit the first 10,000 shillings of your property. In the alternative, 20% of the value of that property, whichever is greater. So if you have property worth 1 million shillings, 20% of that 1 million shillings will be 200,000. So compare 200,000 to 10,000, 200,000 is greater. So that is what she will inherit. Absolutely. The remaining 80%.
Wakili?
Yes.
Do not tell me where the 80 is going.
Yes.
Let us first allow that to simmer in.
Yes.
Yeah, ladies in the house, matters look like that. And we're taking our first break.
Right.
But when we come back, I want you to tell us where the 80% goes.
Okay.
And I also want you to define what a wife is, because understand my student nature.
Yes.
Lawyers have interesting language.
Yes.
So I'd want to know who is the wife.
All right.
That clarity, and also where the 80% goes as we break down going forward.
Yes.
And of course, informing you as I also get informed. This is Law Matters, where the law matters. We take our first break. We'll be back in a moment, getting more, of course.
Miti miti, panda panda, miti miti. Our planet's future is in our hands. However, there is a threat to the brightness of this tomorrow. On EarthCheck, we share the challenges, the solutions, and the hope.
I would call this a very momentous day, a very critical day.
Every episode, every story, every step we take creates a ripple. Join me, the environmentalist Emmanuel Kutosi, on KUTV every Wednesday at 8 p.m. and be part of EarthCheck. Welcome.
Kupanda shuka akawa tuzo, ukakamavu wake ukatii na kumfanya mwenye bidii. Kwa machozi na makeke akabaini jinsi ya kuwini. Huyu ni mwanamke ngangari kwa jinsi alivyo ng'ari ng'ari.
Mimi ni mwanamke mwake mwake.
Usikose kutazama kipindi cha mwanamke mwake mwake, nami Caroline Kimwele.
Welcome back to Law Matters. Of course, this is where we break down the chunky matters of law and bring them to understandable bits. And today we have quite the conversation. We're talking about matters of succession, particularly on matters where you may find yourself intestate. What does that mean? It means if you were to pass on without a will, the law will decide how your property goes, of course, whether you like it or not, because you're no longer here. So before we took our break, we were on the motion of first understanding who a wife is, and also we'd broken down that if you have a wife and you do not have children,
Yeah.
and you're interested and you move on to the other side,
Yeah.
your wife will get your personal effects,
Yes.
then 10,000 shillings of what you may have, or 20%
Yes.
of your whole property.
Yes.
Absolutely.
Yes.
Then we had the 80%.
Yes, correct.
Actually, here is where we wanted to know, where does the 80 go?
Now, this 80% devolves back to the estate. You remember when I talked about where a person has a wife and children, this person's wife would get the personal effects, and then the remaining estate would be held by the wife
Life
in
interest.
trusts of the children, life interests in trust of the children. She does not own them. The same happens to this. She will only have own 20% or the first 10,000, whichever is greater. the remaining 80% divorce back to the estate. So where this person does not have children, then it now start devolving to the parents, to the siblings, grandparents, half brothers and half sisters, creditors and trustees, and if at all we do not have anybody in that lineage, then the property will devolve to government in unclaimed assets.
Okay, I think that has simmered down. But before we go far, I also want to understand.
Yes.
Who's the wife here?
Now, the law of succession is quite interesting. First to note, the law of succession is very independent from the law on marriage. We have the Marriage Act that talks about marriage and who you would call a wife, who you would call wives. The law of succession also has its own definition of what a wife is. Let me start with the marriage side. You know the systems of marriage in Kenya, the civil, the Islam, the Christian, the Hindu, and the customary. For instance, if you are married in Christianity, you can only marry one wife. If you are married in Islam, you can marry up to 4 wives. If you are married in customary, you can marry as many wives as possible. When you come to the law of succession, customary does not have an issue because you can marry as many wives and all of them will be considered wives. The Law of Succession Act does not apply to Muslims. Again, just to be clear, the Law of Succession Act does not apply to Muslims.
Perhaps you can tell us why.
It is exempted in law. The Muslims have their own Sharia law that states how their property can be devolved. But often, more than not, these Sharia laws have also been challenged in court, and some of the distributions have been found to be illegal and unconstitutional, but they are challenged on the basis of the Constitution of Kenya and not the Law of Succession Act. Now, when you come to Christian marriage or civil, you can only marry one wife. But we have a section in the Law of Succession Act, called Section 3(5) of that Act, that excludes the provisions of any other written law on the definition of who a wife is. So, for instance, in the Marriage Act, if I marry in Christian marriage today, I cannot procure a customary marriage tomorrow, or I cannot get a Christian marriage today if I had already procured a customary marriage, because it will simply mean that I'm having 2 wives, and Christianity does not allow that. Same to civil marriage. But if you come to the Law of Succession Act, that provision states this way, that notwithstanding the provision of any other written law, a woman is a wife for the purpose of succession, if at all, whether before or after her marriage, the husband had procured a polygamous okay, let me put it this way. If a woman is married under a polygamous or customary marriage, a polygamous setup, but before that marriage, her husband had procured a monogamous marriage. Before she was married, her husband had procured a monogamous marriage, maybe a Christian marriage. In the Law of Marriage Act, this woman cannot be called a wife. But in the Law of Succession, this woman is a wife for the purposes of inheritance. Same as a woman who is married under customary, but this husband comes again after her marriage and procures a monogamous marriage, either Christian or Christian or civil. Still, this woman is, for the purposes of succession under the Law of Succession Act, a wife. So the Law of Succession has its own way of defining a wife. So the wife is that who is recognized in the Marriage Act as the wife, as well as that which is defined under Section 3.5 of the Law of Succession Act as a wife.
So, Wakili, just to find clarity for the setups that sometimes we see in our society,
Yeah.
where you have found someone who you think you can actually have the journey with,
Yeah.
but on the way, you journey out.
Yes.
Does the law see them as a spouse per se?
Journey out to mean you divorced?
No, you just leave the world. You now go and you're interstate. Let's say I was with someone.
Yes.
And we began our journey.
Yes.
3 months in, I go to the other land. I pass on. What happens? Does the law recognize this person as my wife?
No. A wife has its own definition under the Law of Succession Act, as I've said. But again, other than what is defined under Section 3.5, 3.5 gives the exception to the general rule of what would be defined as a wife. Otherwise, you'll get the definition of a wife in the Marriage Act. Yes. A wife is somebody who you've procured marriage with and you are officially married. You have a certificate of marriage. That is a wife. So if you cohabit with somebody for 3 months, 1 year, 2 years, 3 years,
You're in trouble.
you are just living together,
Okay.
but you are not husband and wife. But we have a circumstance called presumption of marriage, where the law presumes that you are married. But the courts have been slow on trying to enforce this presumption of marriage, and has been putting people on toes. Even the Marriage Act that was amended has told people to register these marriages. So if you stay together, assuming that you are married, sometimes the court will find out that you are not married. The court will make a determination that you are not married, even if you are together for 10 years. That presumption of marriage comes with its own strict steps of measure. You just don't stay together. You stay together for a long time. You invest together. You hold yourselves out as husband and wives. The whole world knows you're husband and wives. You intended to get married. It was not about sitting together and staying together. You actually had the intention of getting married. You had the capacity to get married. If you want to get married in civil, you cannot have another wife back home under customary. You don't have capacity to marry. If you want to get married in Christianity and you have another wife back home under customary, you have no capacity to marry. If you had married under Christian and now you have found another lady and you are cohabiting for 12 years, 15 years, you have no capacity to marry. So you should have the capacity to marry. Even this person you are marrying should have the capacity to marry. They have sane status of mind. They are of right age. So the definition of a wife must be referred back to the Marriage Act. Section 3.5 only gives the exception to the wife. So presumption of marriage is there, but the courts are slow in trying to impose presumption of marriage. So again, on this session today, let people register their marriages to be safe. Yes.
Well, you've heard it from Wakili. In case you're having a very amorphous situation, try and make it functional. But Wakili, I'm going to ask you this.
Yes.
Is it that the law was out to just look at men? Because a man may die intestate, but can't a woman die as well? What happens in such a situation where it is not the man who has gone and now his estate? Because if everyone has an estate, even my wife has an estate, what happens when they exit this?
Okay, let me respond to it this way. My thinking would be that by the time the Law of Succession Act was being drafted, around 1980s, it was being drafted by, who makes laws in this country, members of parliament. First, it was difficult to find a woman in parliament during those days. So the assumption of that law as it was being drafted then was that men are the only people who can own property, because during those years women were not empowered to own property. The assumption was that men would die first and leave their women. Of course, you can see that even to date, women tend to live longer than men. So the assumption was that men die earlier, they predecease their wives, men are the only people who own property, men are in control of the property. And that's why you see even the Law of Succession Act, as it is being worded, you see even some sections, for example, Section 3.5 would define who a wife is for the purpose of inheritance and succession, but does not talk about the husband. Section 29 talks about wife or former wives, but and gives wife and former wives absolute right to inherit even without being taken care of by the husband. But Section 29C, which was declared unconstitutional by the court, now talks about if the husband is the one who has been predeceased by the wife and the husband is left alone, then for you to inherit from your wife, you have to prove to court that your wife was actually taking care of you. Ulikuwa umewekwa.
Interesting choice of words.
Yeah. So if you do not prove that way, then the courts were not giving you that opportunity to inherit from your wife. But that section has since been declared unconstitutional by the court, and men are now safe. Wanaweza wekwa. You can inherit from your wife without really proving that you are being maintained by your wife.
Okay.
Yes.
And just to piggyback on what you've noted, you noted that wife, as the law is right now, cannot sell this property for any reason unless they get that authority from the child, who must be above 18 years old.
Correct.
Let me give you a situation. So this is a family of 3.
Yes.
Father, mother, and the son. They are married, and the man moves to the other realm. The wife is left here, and for some reason the child does grow, and maybe there's a situation, maybe it's illness, maybe it's an issue that risks bankrupting them. Does this woman in this capacity, because one, the child is not maybe in capacity to be able to enforce any decision, does the law create room that they can be able to navigate and still solve various issues that they may encounter before this child is of age? Does the law create a room for that?
Yes. The law creates a room for that. There are circumstances in which the circumstances which can present themselves as very urgent circumstances that may need urgency in addressing them after the deceased person has died, and which, if you follow through the entire succession process, by the time you're done, then some eventualities might have occurred which are not very desirable. Let me first speak to the situation you've painted. For instance, a man dies and leaves a small child or a child in school. This child needs school fees. This child can fall sick and needs medical attention. And maybe the school fees and the attention come almost immediately after the death of this man. The wife can go to court and seek something called limited grant. A limited grant is a grant issued for a particular purpose. A man can have lots of money in the bank account, but a court can give a limited grant that is limited to withdrawing certain stated amounts of money in that grant for the purpose of paying these school fees. So when you're approaching court for a limited grant, you have to state what is the purpose of this grant. What do you want to do with it? And which a grant is like an order that this person has been granted this limited grant for the purpose of withdrawing money from NCBA bank account number this, it is even stated, and the amount to be withdrawn is this during this and these durations of time, and for the purpose of paying school fees for this, or for the purpose of settling medical bills for this person in this hospital and for this account. So there is that room in law. So a child will not die and yet the parents or the father or the mother had this amount of money in their accounts. A child will not die if they have this property and the mother is holding this property on interest of this child, and the child is not able to consent. This lady can move to court for the court to grant authority for this property to be sold, so that medical bills and school fees can be sorted. Yes.
And Wakili, there is a term that I came around, bona vacantia.
Yes.
Very big term.
Yes.
Sounds something very foreign.
It's bona vacantia.
There we go.
Yes.
There we go. Bona vacantia.
Yes.
Yes. Now I think I've gotten it right.
Yes.
What does that mean?
Bona vacantia simply means that there has been no identifiable beneficiary or dependent in the lineage of the deceased person, and in that instance the property will revert to the government. So if you die, you have no wife, you have no child, you have no parents, you have no grandparents, no half brothers and half sisters, no cousins, then the property will devolve to government through that doctrine of bona vacantia. Yes. So it will go to the unclaimed assets of government. Yes.
Would it be termed an unclaimed asset, or does the government take it in its own right because there is no one else to claim it?
You see, a government is most of the time, even when we are studying land law, we are told government holds the eventual title. So yes, it would be entitled government as an unclaimed asset from the citizenry. Yes, and now it will be property of government. Not really of government, but it will be under, we have an unclaimed assets agency in this country. Yes, so there are assets that are just left, nobody comes to claim them, then the government takes them and puts them under the agency.
Perhaps I'm going to have you for another conversation.
Yes.
To understand if it becomes an income of the state of some sort, since I had no one else to leave my property.
Okay.
But it's something that we can be able to walk over and also understand.
Yes.
Maybe it is even something that may quicken our steps towards, nuptials.
Yes.
As they would be. Yeah. Well, we're taking a second break. But when we come back, we're going to have the audience sharing their questions. Also, wherever you are, right there, you can be able to use the WhatsApp number that is on your screen and also share your questions to Akile Hillary. He'll be able to break them down. And of course, also through our social media handles. We are at KUTV Kenya on Facebook and KUTV_Kenya on the X platform. Engage with us. Let us get your questions in within this break and break them down one after the other. You may have questions that I've not been able to touch on. You're the one who has the power now to share your questions and see them answered.
Msimu mpya, uso mpya, nguvu mpya, bila shaka na ari mpya, lakini dhamira ni ile ile: kuboresha kilimo kwa maisha bora. Jiunge nami James Baraka na hudha wako mpya wa kipindi cha Boresha Kilimo, tunapochunguza mbinu za kisasa za kilimo, ukipenda teknolojia ibuka katika kilimo, maoni ya wataalamu na hadithi za mafanikio kutoka kila pembe ya taifa. Kutoka kwa wakulima wadogo hadi biashara za kilimo zilizostawi, tunakuvika maarifa na suluhisho kamili, si tu za kuongeza mazao yako, bali pia kuimarisha maisha yako. Kila Jumamosi saa 6:30 na Jumanne saa 4 asubuhi, usipitwe na baraka za Boresha Kilimo, nami James Baraka, hapa KUTV.
So my name is Jakub Petri. I'm Associate Professor in the Institute of Philosophy of Jagiellonian University in Krakow, Poland. And I'm the main coordinator of the CAFE project, which is being here hosted by Kenyatta University.
My name is Ewa Hudoba. I am a project manager in this consortium. Keep watching cutting edge research at Kenyatta University Television.
All right, welcome back to Law Matters, where we break down chunky matters concerning our law right here in Kenya and break it down into bits that are manageable, particularly today as we look on matters of succession. So far, we've come to the realization that it may be a risky place to be if you are intestate. Don't know what intestate is? Go back to the beginning of this program and you can be able to engage with the discussion as it were. I'm joined by Advocate of the High Court, Hilary Musoma, and we've had quite the run.
Yeah.
And there is one question I want to shoot your way. We've noted that, one, children will get the divisions of property of an interstate person equally.
Yes.
I mean, the question of maybe we are children here.
Yes.
And our old man has moved.
Yes.
And there is property to break down. But for the three of us, we are 18 and above. But we have maybe another set of three who are not in capacity to execute anything because they are under 18.
Yes.
Does the law protect them from us in the likelihood that we decide to become vicious and take everything?
First, I must admit that we have vicious characters who'd want to have everything for themselves. Mm-hmm. But there are avenues to address such things. Let me begin this way. You know, before you start devolving that property, you have to get authority from court. Before you divide that property equally amongst yourselves, you have to get authority from court. And you have to get an authority called the grant of letters of administration. And the court will appoint administrators to an estate. Now, here's the difference. When you write a will, you can decide to appoint a person and say, this person will be in charge of distributing my estate. That one will be called an executor of the estate. But when you choose to die without written a will, the court will appoint people called administrators of the estate. But when you are petitioning, it's actually called a petition. When you are petitioning for the letters of administration, you actually list the beneficiaries in that estate. You list the dependents. You list those people who are survived by the deceased. You will list yourselves, the three who are above 18. You'll also list those minors who are below 18. Now, when you have been granted that those letters of administration, and you're now the administrator of the estate of person Y, X, Z as the deceased person, when you are transferring those properties, when you go, for example, to the land registrar, land registrar will transfer all those properties to your name as the administrator. But they'll not bear your name absolutely. For example, if my name is Musoma Hilary, that title will be written that I hold the title Musoma Hilary, but in brackets it will be written as administrator of the estate of person XYZ. Mm-hmm. So it is not a title that I'm holding Musoma Hilary. I'm holding it as the administrator. So that when I come to the distribution of the property, I'll be transferring that property as the administrator of the estate to every other beneficiary, including those children. So provided those children are not 18 years, I'll still hold that property in trust for them as the administrator. As soon as they're 18 years, I transfer the property to them. Mm-hmm. But sometimes we have people who lie in court. They connive with their chiefs. Before you get the letters, you need some letter from the chief to confirm how many beneficiaries were left. They lie. They connive with the chiefs, and the chiefs write letters and say that only these 3 were left, are survived the deceased person, leaving out the others. And then the court goes ahead and grants those letters, and you distribute properties amongst yourself. These 3, when they get to the age of 18, they can actually go back to court and revoke that grant. And when they revoke that grant, it means that the title deeds that were acquired from the fraudulent process are also fraudulent titles. Whether you sell them to 100 other people, all those 100 title deeds would be fraudulent. And so they'll be cancelled and nullified by the court, and the whole process will have to start afresh. Yes.
Well, that is well put.
Yeah.
I hope well understood, even to you at home. We invite you to the conversation. The number is on your screen. Share your questions, and also on our social media handles. And Wakili Musoma,
yes,
we have an open lecture here.
Okay.
We have a live audience, and I'm going to engage them for their questions particularly. Kindly tell us your name and also submit your questions.
Good evening to all. My name is Kivuva Regan, LLB finalist, Kenyatta University School of Law. So my question would be on the limited grant. Let's say with these vicious characters, what would be the likely recourse for such? Because we understand that these are kids and they need maybe an ex-friend, and you find that this next friend is the person who is vicious. So do they have to wait till they're 18, or what kind of recourse do the courts offer them? Thank you.
Good evening. I am Udhiambo Titus, LLB student 3rd year in KU, and my question to Advocate Hilary Musoma is a very simple one. In conditions where you marry, then maybe the wife comes with other kids, right? Then are those children also bona fide to inherit some of the properties? Yes, the kids out from the wedlock, yes, are they entitled to inherit something from the will?
Okay, thank you.
Oh, my question to...
Your name kindly?
My name is Peter Machare. My question to Advocate Musoma is, what happens if a person who was mentally sane dies? Now the property, the person is mentally sane, then he becomes insane. So what happens to his property? And he had no will.
Okay, hi everyone. My name is Andati Abuya, Legal Aid President, LLB finalist, KU School of Law. So my question to Wakili Musoma is, you've stated that the court, or rather the law, has its own way of interpreting who a wife is. So what happens when I meet someone, I get married to that particular person, yet that person lacks the capacity because he had already, or rather he was already married some time back, yet I'm not aware. Then we've lived together, for example, for like 15 years. So in case such a person dies, do I stand to gain like anything from him, or just the wife?
Could you do those first?
Yeah, proceed.
Okay, I will answer those questions. Let me start with Andati Abuya's question. If you are staying together for 15 years, first, you cannot have been married if this person was married before. So probably you are staying together, just cohabiting. If that was the case, and this person had been married in another system, and especially a system that only could permit monogamy, if that system that this person was married could only permit monogamy, then you who is married right now, if you are married under a system that only permits monogamy, you do not have capacity to marry, if we have to go that route. If you marry under a system that permits polygamy, then you will be treated as a wife under Section 3.5. But again, if you want to be treated as a wife in the sense of presumption of marriage, then you will not be treated as one, because presumption of marriage has its own conditions. You must have the capacity to get married to that man. So if that man had procured a marriage before, and that marriage only permits monogamy, you do not have capacity. He did not have capacity to marry you, and so you not be considered a wife in the sense of presumption of marriage. I'll go to the second question, which was asked on the issue of children.
Mm-hmm.
If I get married and I get married to a lady and she comes into my house with her own children, she comes with 2 children, and then we sire 2 more children, so that we have 4 children. If I die a billionaire, the only persons entitled to inherit from my estate are my 2 biological children. The other 2 children are strangers. The only exception is if I adopted those children legally, and there are processes of adopting. There are processes of adopting, and adopted children are treated as children of the deceased person. So if this lady comes into this marriage with her own children, let this man adopt those children and have those children's documents reading him as the father of the children. Otherwise, these are strangers to the estate of the deceased person. The same would happen if I come to the marriage myself as a man with a child, and the lady comes pure without a child, and we sire children. If she dies a billionaire, my child will not be entitled to inherit from my estate unless that lady adopts that child.
Mm-hmm.
Yes.
There was a question on one who's insane.
Oh, on the person who is insane. Yeah. She was insane or he was insane, and after some time they ran mad or became insane, and they die, but they own property. Did they have children? Yes. Are the children of age? Can they petition for grant of letters of administration later on? Yes. Did she own property? Did he own property? Yes. Can the property devolve? Yes. It will be treated like any other normal succession process.
Mm-hmm.
Yes.
Well,
succession is not defeated by the fact that a person was mentally ill. Mm-hmm. The only place where that would be defeated is in witnessing a will, where a person who is not mentally sound is actually a witness to a will.
Okay.
That one will fail. Yes.
In the benefit of time, since we are wrapped up for time,
yes,
I think we're going to answer Regan Kivuva's question later on.
Yes.
Because we are really tight for time.
Okay.
But I really appreciate the time.
Thank you.
Hillary.
Thank you so much.
You can have some final 1 minute remark, then you work it out.
Thank you. My one remark would be this. People should be encouraged to put their affairs in order before their time comes. It doesn't matter. You know, we Africans have this fear that when we begin writing wills, we think that we are dying. No. The problem would come when we fail to write those wills and something happens and we vacate this world without putting our affairs in order. And then those left behind us are left wrangling over property. So to avoid the wrangles, let people put their affairs in order. But also, where we have malicious and vicious people who are gluttonous and want to inherit everything, there are recourses in law, and there are ways in which those letters of administrations or the letters of administrations can be nullified, and the state can revert back to the deceased person, and the normal process of succession will follow thereafter.
Thank you very much, Wakili.
Thank you.
Of course, and thank you to you, wherever you are watching Law Matters from. Of course, the law does matter. Today, we have been able to talk on matters concerning how not to be intestate. Particularly having a will is not a matter of death but a matter of life, a matter of love and protection for those you leave behind. Of course, be sure to catch us once more right here on KUTV for more matters concerning the law on the Law Matters show. My name is Emmanuel Kutosi. See you later.
Are you an aspiring media practitioner, a graduate, or you just want to advance your skills in television production?